Grove holder. So section 194 to 205 is explaining grove holder. Section 194, rights and liabilities of a grove holder. Notwithstanding anything that is contained in chapter 7, a grove holder may cut and sell trees and may replant trees as they are cut or die. Subsection 2, subject to the provisions of section 63, which shall apply so far as may be to a grove holder as they apply to a tenant. The rights of a grove holder shall subsist too long as grove land retains its character as such, and on such land ceasing to be grove land, the grove holder shall become a khatedar tenant thereof. Third, grove land be liable to division in accordance with the provisions of section 53, which shall apply so far as may be to a grove holder as they apply to a tenant. Subsection 4, where a person becomes a grove holder in respect of land of which he is a tenant, he shall hold such land as a grove holder in suppression of all subsisting rights and liabilities so far as they are inconsistent therewith. 195 section, rights to make improvement. So a grove holder may take an improvement which a khatedar tenant may make, and provisions of chapter 6 shall apply to him as if he were a khatedar tenant. Then in section 196, that is telling about the devolution and transfer of interest. So the interest of a grove holder shall devolve according to the personal law applicable to him. Subsection 2, a grove holder shall have the right to transfer the whole or a part of his holding by sale, gift, or mortgage, and the restrictions imposed on such transfers by khatedar tenant shall not apply, provided that in case of a transfer by mortgager, such transfer shall be in the form of an unsuffragatory mortgage for a period not exceeding 20 years, and the provisions of subsection 2 and 3 of section 43 shall apply thereto. Now, subsection 3. A grove holder may sublet the whole or any part of his holding, and the restrictions imposed on subletting by section 45 shall not apply, provided that no subtenant of grove holder shall have any of the rights conferred by this act or subtenants other than those that are conferred on him under the provisions of this chapter. Subsection 4, a grove holder may also, by written agreement, grant a farm or lease for the collection or sale of produce of his grove for a period not exceeding 3 years at a time, and the rights and liabilities of such farmer or lessee shall be governed and regulated by, and shall be enforceable in revenue court of competent jurisdiction in accordance with the terms of such agreement. So section 197 is talking about the provisions regarding the rent. There is a proviso that the rent shall be payable in accordance with subsection 1 by a grove holder on these two following cases: when upon the, like, first is when upon the commencement of this act or upon the expiration of 30 days from such accusation, whichever is later, if the premium paid by him exceeds 10 times the annual rental of the holding then prevailing. Second is same, but when the upon such commencement or upon the expiry of the period of 15 years from such acquisition, whichever may be later, if the premium paid by him did not exceed 10 times such annual rent. Third is the rent payable in respect of grove land by a subtenant to a grove holder shall be in cash, and shall be as may be agreed upon between him and his subtenant, or uh, as such agreement tells, as may be determined by the competent revenue court. There is a proviso that any condition that is mentioned in the agreement under this subsection for the delivery of a specified portion of the products for the personal use of the grove holder in part payment of such rent shall be deemed to be valid. Fourth, the provisions of chapter shall apply to grove holder as they apply to khatidar tenants. 98 is about ejectment. First, while the land continues to be grove land, a grove holder shall be liable to ejectment only on any of the grounds that are mentioned in section 177 and in the provisions of section 161, 162, 164, 165, 166, 167, 168, 178, 179, 184, 185, 186, 187 and 188 and it shall apply to him as if he was a tenant. Subsection 2 is a grove holder who is a trespasser. He will be liable for ejectment in accordance with section 183. Third is a subtenant of a grove holder shall be liable to ejectment on any of the grounds that are mentioned in section 175, 177, 180, 183 and the provisions of chapter 11 shall apply. Fourth, a farmer or a lessee of a grove holder shall upon suit be liable to ejectment on the grounds of contravention of the terms of his agreement. Now section 198A. So application of chapter 7th, 25 and 26. Sorry, 8th, 25 and 26. The provisions of 28 chapter 25, 7th chapter, 25 chapter and 26 chapter shall apply to grove land as if the grove holder thereof were as khatidar tenant. Section 199 rights exercisable by an izaradar or thekedar. First is except as otherwise provided by the terms of his izara or theka, an irasadar or thekedar may exercise during the period and to the extent of his izara or theka all the rights of the lesser under this act. Exceptions to this is first, when the right to sue for the enhancement of rent or ejectment of a tenant. Second, the right to make an improvement or grant permission for making of any improvement. Third, the right to cut trees. Fourth, the right to sue a grantee at favorable rate of rent under provisions of chapter 10. Then second subsection is the right which may be exercised by a isradar or thekedar under the foregoing subsection shall not be exercised by the lesser during the period of izara or theka. Now section 200 restrictions on the transfer or succession of izara or theka. First, the interest of an izaradar or thekadar first shall not be transferable in execution of a decree or order of any court. Second, save as provided by the terms of izara or theka shall not be otherwise transferable or be heritable. Second, subsection of section 200 is where the interest of an izaradar or thekedar is heritable, it shall devolve according to the personal law applicable to him. So the grounds of ejectment, an izaradar or thekedar shall be liable to ejectment on one or more of the following grounds. The first ground is that the rent due from him has not been paid in full. Second ground is that any act or commission prejudicial to the right of the lesser or inconsistent with the purpose of the izara or theka has been done or made by him. Third ground is that he or any sub izaradar or sub thekedar under him has broken a condition on breach of which he is by the terms of izara or theka liable to be ejected. Fourth, that the term of izara or theka has expired on or before the end of the current agricultural year. Next is last ground is that his treatment with the tenant or other residents of the village has been oppressive. Section 202 how to proceeds for ejectment. First, when a lesser other than the state government desires to eject an izaradar or thekedar or any ground, he shall proceed by suit. 203. Remedy for wrongful ejectment. An izaradar or thekedar who has been wrongfully ejected from the whole or any part of the izara or theka area, or wrongfully prevented from exercising his right as izaradar or thekedar by the lesser or any person claiming under or an agent of the lesser, he may sue for compensation for such wrongful disposition or unlawful interference. 204 is surrender. So, an izaradar or a thekedar may at any time, with the consent of the lesser, surrender his interest in the izara or theka area.